Yeah. But I think in terms of online publishing, the number one recurring one, and this has been true for a couple years now, is kind of that species of claim like you are defaming me by archiving a police blotter item that makes me look bad, and I'm demanding that you pull it down out of your online archives. That's a recurring fact pattern, a question that we get over and over again. And it has both a legal and an ethical dimension to it, I guess. The legal issue is pretty simple, which is that if something wasn't defamatory at the time that you wrote it, it doesn't suddenly become defamatory just because it's now bothering me 10 years later. So if it meets the test for being lawful 10 years ago, then it's lawful today, as long as it doesn't falsely accuse me of a crime I didn't commit or falsely state some other damaging fact about me. Then it's not defamatory, and you have every right to publish it. So that's the legal answer. Additionally, if it really is a 10-year-old item, then the time clock to bring a defamation claim has long since expired anyway. So anybody that is rattling the lawsuit saber and saying, I'm going to sue you over a 10-year-old item, has almost certainly slept on their rights too long. And so that claim is almost certainly dead. But, there are ethical and judgment issues that get involved in this too. It's a little complicated from an editorial judgment standpoint when somebody is able to show that you reported that they were accused of a serious crime, but you never reported that their name was cleared and that all the charges are dropped. So even though legally you haven't done anything wrong by archiving that police blotter item, your ethics and your judgment and your standards might be telling you, maybe I should update that. Maybe I should append some additional information on there to give everybody the complete story. And that's totally fine to do that, but A, you want to make sure that there's documentation of it, that you're not just taking this person's word for it, that they can provide you some documentation. And B, you want to be real careful about getting in there and actually rewriting the initial item. In other words, I wouldn't go into the police blotter item and rewrite the text of that item. The reason being, there's something in the law called the single publication rule, and once something's been published one time, then just publishing an identical new version of that on your website is not a brand new publication. It doesn't restart the libel clock. But if you publish an altered version, a changed version, a revised version, then you might restart the libel clock. So you might be giving that guy another year or 2 year window to sue you over something that that was long since dead and gone. So the better practice is, number one, to just append it onto the end like an editor's note rather than revising the text. And number two, ideally to get some kind of a release from that aggrieved person, right? Some kind of a written statement that says, if you add the following paragraph, I'll release any claims that I might have against you, and then go right ahead and do it. The other one that's kind of interesting, and we don't have a particular legal answer for this, but I do think it's something everybody at least needs to have a discussion about and do some thinking about at the start of a term, and that is who has the keys to the website. In other words, there's a little bit of a potential censorship issue at a public institution if you have an instructor, a government employee who's acting as the gatekeeper of the website. We've run into this from time to time, where it turns out that the advisor has posting privileges, and the advisor is using their privileges to put up and take down material. And there is some risk of running afoul of the First Amendment if the advisor is going in there without the permission of the editors, maybe even against their wishes, yanking down pieces of content. So you just want to be, the advisor, I think, understands that they couldn't do that on the printed page, that they couldn't go over the shoulder of the editor and push the delete key and kill things out of the print publication. So you should establish the same kind of boundaries responsibilities with the online publication as well. I'm not saying there should be a per se rule necessarily that the advisor doesn't have those privileges, but there should be some understanding of how those are to be used. You know, the concern comes in, the practical concern is that there are going to be times when the students disappear from the campus, and the advisor or the business manager or the general manager might be the only person who's physically sitting there at the desk when the phone rings with the aggrieved person who is demanding that you pull down the content. So if you're going to restrict access to the website to the student editors, and you're not going to give that advisor the key to the website, then you need to have some kind of a coverage plan so that there's always a student who has takedown ability who's reachable, you know, some kind of a shift where if you, the editor-in-chief, go skiing over Christmas time, the managing editor is reachable. The managing editor knows that it's their responsibility if they get that phone call, you know, hey, your website's been hacked, and there's some, pornographic material or some material that's defamatory, and it needs to be pulled down right away, that person has the ability to do that. Yeah. Well, I mean, I would say two things there. One, you know, the biggest thing to understand is that the rules aren't fundamentally different. I mean, I think people often have the perception that online publishing is a different species and that it's qualitatively different from print publishing, and really it's not. I mean, with a couple of exceptions, and I'll talk about one in a second, all the same rules pretty much apply. The Supreme Court has said that the same First Amendment standards apply to the internet as would apply to a printed newspaper. So publishing is publishing is publishing is publishing. That also means, by the way, that you can libel somebody in a tweet, you can libel somebody in a Facebook post, or you can libel somebody in an online publication every bit as effectively as you can libel them in print. So all the same rights and all the same responsibilities and risks apply equally. So that's the first thing to understand. So where the rules diverge, where they deviate, the big one is third-party content, right? Reader comments. And that is another huge area that I think people, both in the student media and in the professional media, are kind of just figuring out, is how do we police or not police what readers come and hang on our comment board. And it's funny because I've only been doing this work for about 3 years now, but just in those 3 years, I've seen an evolution, a sea change in the practice, both in the professional media and in the student media, where it used to be kind of a cherished belief that anonymous speech was to be valued and protected, and that we wanted to encourage people to come and post anonymously so that they would speak openly and freely. And now the pendulum is swinging back a little bit toward preferring that people sign their names to their comments, because what we found out is that anonymity also encourages a lot of people to do some stupid, crazy stuff, like spout off their racial hatred on your comment board. And come to find out that racists are not that brave, and when you require them to log in using their real email address, suddenly their courage evaporates and they stop doing that. So a lot of publications have started either requiring that you log in through a portal like Facebook, or that you at least provide a verifiable email address, or they've preferred those comments. In other words, they have a hierarchy system where a named comment is going to float to the top of the comment board, and an anonymous comment is going to sink to the bottom of the comment board. And so, you know, as a practical matter, it's probably not going to get seen or read anyway. But the policing of the online comments is a huge area of uncertainty, and that is one where the law is different. You know, in print, if I publish a letter to the editor, if I publish your written letter, that's my content. I'm as responsible for that as if I had assigned it to you and I had paid you for it. So if you libel somebody in that letter, I've got ownership of that as a publisher. Not true on a comment board. That's the Federal Communications Decency Act, Section 230. What it says is, if you're the provider of the website portal, basically, and you do no more than hang out a board for people to post their comments on, that as long as you're not the co-creator of those comments, that's not your speech. You're not liable for it. The person who's offended by it, the person who's aggrieved by it, can always go after the author, that person is liable if they can find them, but you as the host are not. That's a specific provision of federal law that applies only to online speech and does diverge from the rules for print. I mean, as a general matter, I certainly think that people need to be mindful that publishing online is publishing, and that you have to apply all the same rules of verification that you would to print publishing. That the fact that you put something out on Twitter and you have the ability to delete it or take it down later doesn't mean that it was never said. It doesn't mean that it was never published. So you certainly need to adhere to the same verification standards before you would make an allegation on Twitter as you would before making an allegation in print. You don't just go floating rumors and saying, well, we'll go check this out later. Once you've published it, and you've got ownership of it. Yeah, it's hard because I think as a practical matter, one of the benefits of Twitter is the immediacy, and if you're going to have an intermediary there, it's clearly going to slow you down. I think you're just going to have to use your judgment and common sense and realize that there are certain types of stories that are going to lend themselves to a libel risk, right? And so I would never say you've necessarily got to have an editor sitting there in the football press box, right? If you're doing no more than providing periodic game action updates by Twitter, the libel risk is almost infinitesimally low, right? I mean, how are you going to libel somebody giving an update on how many yards the running back has, right? So I don't think I would ever say, yeah, you've got to have an ironclad rule that nobody ever puts anything on Twitter without an editor reading it. Because your judgment and your common sense are going to tell you that a venue like that, or a concert, an entertainment event, you're just not you're not at high exposure for defamation. But certainly, if it's any kind of a political function, if it's crime news, crime news is just a magnet for trouble because it is the kind of thing where if you name the person incorrectly or you exaggerate the criminal charge against them, that can be slam dunk defamatory. So yeah, you really, I would certainly not give my police reporter a BlackBerry and tell them, go down to the police station and start live tweeting the police blotter. I think that's an invitation to trouble. But yeah, so I think you just use your judgment and common sense about how sensitive the material is. And and just give everybody obviously a good grounding in defamation law. Everybody in the newsroom, even the sports writers, even the photographers, everybody ought to have just a basic grounding in the rules of defamation and invasion of privacy, so that they can go out and tweet safely.